Hello and welcome to the Law Lab. Here we dissect and unpack everything legal. My name is Jacqueline Opoku. Today we'll be discussing illegality of a contract and the enforcement of an illegal contract. We'll look at what illegality is, what makes a contract that looks like legal to become illegal, and the effect of illegality on the performance of a contract. A contract may be complete in all forms, meaning you have formed the contract, there are no vitiating factors that will make the contract void or voidable. But due to certain circumstances, the complete contract would then be rendered illegal. Therefore, the court will state that an illegal contract cannot be enforced by the court. Due to this, our discussion will center on what constitutes illegality of a contract, the effect of the illegality of the contract, and whether the effect is from the inception of the contract or where the parties are performing. That's where it causes the contract to be illegal. There are two factors that make a contract illegal. The first factor is public policy or public interest, and the second factor is statutory regimes. To discuss the statutory regimes, you must consider the laws that make a contract that would have been legal illegal, meaning a contract that has been formed by two parties have undergone the necessary formations and there are no vitiating factors, will become illegal if the contract in itself has been forbidden by an existing rule of law. This means that any law that makes a contract illegal, the contract cannot be enforced by the court, or the contract will be considered to be illegal and therefore the court will not lend its helping hand to enforce such a contract. For example, if a contract is formed and the Contract Act of 1960, Act 25, renders the said contract to be illegal, then the contract cannot be legal and therefore cannot be performed by the parties. Another thing you have to consider is the Constitution of Ghana, the 1992 Constitution of Ghana. If the law specifically states that certain acts or certain contracts, when contracted by parties or when entered into by parties, cannot be enforced by the court, or that the contract is illegal, then no matter what the parties do, the said contract will be illegal and therefore will be void ab initio. That is, it will be void from the inception of the said contract. The second factor we'll be considering is a contract that has been formed and it is against public policy or public interest. Public policy or public interest means that anything that has to be of the best interest or should serve the best interest of the society, and therefore if such action does not serve the best interest of the society or the public, the said action will be rendered illegal. This will consider under contract law. When it comes to contracts that has been formed by parties or entered into by parties and it is said to be illegal because of public interest, that means that the contract, although between the parties, may be legal, but when we consider the public at large, the contract will be considered or rendered illegal. The first example that we'll consider is a contract that is entered to commit a crime, fraud, or a tort. For this contract, it means that a contract has been entered into by two parties or two or more parties, and they have agreed to enter into this contract with the perception or with the intent of committing a crime. For example, A and B enter into a contract to sell marijuana. In this case, since Indian hemp or marijuana is an illegal substance which the law is against or public interest is against, so far as they've entered into a contract to sell these kind of things, it cannot be enforced by the court and the court will render such a contract illegal. The case we'll be considering is Sadler versus Moore. In this case, the defendant was no longer part of a tobacco association because he had committed a crime and he had been sacked. Knowing this, he entered into a contract with the plaintiff without telling the plaintiff that he's no longer part of the tobacco association, knowing very well that he could not sell the tobacco to him since he was no longer a party or he was no longer part of the tobacco association, and went ahead to sell the tobacco in the name or acting like he was still part of the tobacco association. In this case, the court held that the act done by the defendant was illegal, which rendered the said contract also illegal, and therefore the parties could not enforce such a contract. Example under contracts which are illegal under public policy is contract to promote sexual immorality. We already do know what sexual immorality is. For example, prostitution or running a brothel or anything that is considered sexual immoral. If a contract is entered to promote such sexual activities that have been deemed by the public not to be moral in relation to sexual activities, such contracts will be deemed to be illegal. So in this case, Pierce versus Brooks, a coach builder built a bus or an ornamental bus to carry escorts to places to conduct sexual immoral acts. And when they did that, the other party who contracted them to build such a bus did not pay them. The court stated that a contract to promote sexual immorality cannot be enforced by the court because it is deemed to be an illegal contract. The third example that we'll consider is a contract to commit an act that is contrary to foreign regulation. If A and B, who are in Ghana or are Ghanaians, decide to contract and breach a law of another country, for example, America, such a contract cannot be enforced by the court due to the fact that it is illegal under the country in which they have decided to perform the contract. Although where they formed the contract may be legal, but where the contract is to be performed, that contract will be rendered illegal, then it cannot be enforced by the court. In the case of Foster versus Driscoll, the court held that to send whiskey through Atlantic to the USA was contrary to the law of US, and therefore such a contract could not be enforced by the court. Another example that we will consider is a contract that is prejudice to the administration of justice. Prejudice to the administration of justice means that it is going to hinder the administration of justice, meaning a contract that will prevent the court or any person from giving or rendering justice to where justice is supposed to be served. That contract will be said to be illegal as is against public policy. The case of Kier versus Lehman, the court held that a contract which has been formed with the intention to prevent justice from being served cannot be enforced by the court, as the court is a place where justice is supposed to be rendered for parties that have suffered injustice. Another example that we'll be considering is a contract to oust the jurisdiction of the court. In most situations, you can oust the jurisdiction of the court where there is an honorable clause in your contract that you do not want the court to adjudicate upon the matter where a dispute arises between both parties. In such a situation, the court will not interfere with the party autonomy of the parties. But where the court realizes that the parties ousted the jurisdiction of the court with the intent of committing an illegal act through the contract they have entered into, with that, the court will disregard the fact that you have ousted its jurisdiction and go ahead to render justice. The last but not the least example we'll consider is a contract to use your public office for private gains. For example, using your public office to receive bribes, to receive anything that is corruption related. Or, for example, A is a police officer who is a public servant and he decides to take a bribe or decides to take anything in order to aid B to get what B wants. That contract will be said to be illegal, as A, who is a police officer, is using his public office for private gain, which is against the law. The case of Ampofu versus Fiorini, where a civil servant used his public office to secure a timber contract, the court held that such a contract was illegal from its inception as it was against public policy. So far, we have discussed what illegality of a contract is, and we've looked at certain factors that constitute illegality of a contract. We have considered the first factor to be a contract which is conducted against statutory regimes or against statutes, and also we've considered contracts which has been entered into which is against public policy. We will now move on to consider another factor which is called contract in restraint of trade. The general law is that contract in restraint of trade is usually illegal, meaning if a contract is to restrain someone from trading, the law deems it to be illegal as Article 24 of the 1992 Constitution promotes freedom of work or the right to work. And therefore, if you enter into a contract and that said contract is preventing you from trading or is preventing you from enjoying your employment benefits, that contract will be said to be illegal. But there are certain situations where an exception will arise and the contract to restrain trade will be deemed to be legal. The first example or the first factor is where a person sells his business to another, the buyer is allowed to prevent the seller from engaging in such trade within a period of time. I will state it again. Where a contract is entered into between a buyer and a seller of a business, the buyer can prevent the seller from engaging in such a trade that he has sold to the buyer. This means that let's consider A and B. A owns a business and decides to sell it to B. B is supposed to reap the benefit of the money that he has paid to purchase the business from A, and therefore can tell A not to contract or not to engage in trade that are similar to the business or that are same to the business that he has sold to B. This is to allow B to get the benefit that he has invested his or her money into. There are certain reasons as to why the court will allow such a contract to be legal. The first reason is that it is reasonable as between the parties for the buyer to benefit from the business that he has bought from A within the time they would have stipulated in their contract. The second one is that it must not be unreasonable as contrary to public policy. For instance, A and B. A owns a business, has sold it to B, and B tells A, you cannot trade in such a business or you cannot trade by selling furnitures. As you sold your furniture business to me, you cannot engage in selling furniture to another person or other people within the next 10 years. Here, it is very unreasonable because within the next 10 years, B would have profited from the business that he had bought from A and would have reaped the profits that are entitled to him. Hence, the contract that you are entering to restrain the other party from engaging in the same trade must be reasonable and must not be contrary to public policy. Another exception is where a person is in the employ of another and he has left or he's no longer working for the other person. You can restrain that person from engaging in such a trade or releasing information about such trade to other people. For example, Ama is in the employ of Kofi, who runs a very big corporation, and Ama was a managing director in such a corporation. For example, they produce biscuits, and Ama decided that she no longer wants to work with Kofi's corporation any longer. In such a situation, Ama being a managing director would be privy to certain information or trade secret that she can use it for her benefit when she leaves Kofi's corporation. And therefore, Kofi can state in Ama's employment contract that when Ama leaves the corporation within the next 5 years, within the next 3 years, Ama cannot use such information that she was privy to also open a business of such similar nature or same nature. Or if Ama is to be employed by a rival company, she cannot disclose such information or trade secrets that she obtained by being a managing director of Kofi's business to the rival company. This is because if Ama is to disclose it to the rival company may overtake Kofi's corporation and be better than Kofi. Or if Ama is to use such trade secrets to also engage in a trade which is similar to what she was in which she was a managing director, that means that she's going to be in competition with Kofi and is going to be against or contrary to public policy. Due to these factors, contract against restraint of trade can be said to be legal in such circumstances. I'll state it again. Contract in restraint of trade is illegal as the law or Article 24 of the 1992 Constitution enforces your right to work or right to employment, and therefore someone cannot contract with you to prevent you from working or prevent you from trading. But there are certain exceptions that you can allow such a contract to be legal. And I've stated that where a buyer buys from the seller, the buyer can restrain the seller within a period of time which is reasonable from engaging in such activities that would be similar to the business he sold to the buyer. The second one is in relation to employment contract, where the employee leaves the employer of the employer. They cannot use trade secret they have obtained for their benefit or for the benefit of rival companies. At this point, we'll be considering the effect of illegality or illegal contract. What is the effect of illegality on a contract that would have otherwise been binding or would have been enforced by the parties? There are two main circumstances to consider the effect of illegality on a contract. The first instance is that when a contract is illegal from its inception, it will be void ab initio. This is due to the fact that a contract which from the beginning or from the formation of the contract, everything about the contract was screaming or was saying that it is illegal, but yet the parties went ahead to enter into such a contract. The court will hold, or the court has held in several cases, that such contracts are illegal from its beginning and therefore are void ab initio. For example, in the case of Olatiboy versus Captain, in this case, the law was that you cannot sell diamond or you cannot export diamond without license. The parties engaged to export diamond without having license and knew very well that they did not have license and still decided to export the diamond without such license. The court held that the contract from its inception was illegal, as there was a law that stated that before you can export or before you can engage in the trading of diamonds, you must have a license to support or to allow you to trade in such activities. But the party not having such license was prevented from engaging in the contract, but going ahead to enter into that contract made the contract illegal from the beginning. The second factor to consider is the contract from its beginning was not illegal until it was performed. That is, the contract at the beginning of it or at the time it was being formed was illegal until a party decided to perform the contract in an illegal manner and rendering that contract illegal. Example, the first thing you have to consider is the party who made the contract illegal by their performance. For example, Ama and Kofi are partners and have entered into a contract to engage in selling or to engage in trading. From the beginning, when they entered into the contract, everything about the contract was legal until Kofi performed the contract in an illegal manner by committing a crime whilst performing his part or by doing anything that rendered the contract illegal. In that sense, the party that made the legal contract to become illegal contract will be held liable for the illegality. In the case of Anderson versus Daniels, the contract was entered to sell a fertilizer and to send an invoice to the other party after everything or after the contract has been formed. The plaintiff delivered the fertilizer without an invoice and was also not paid, and therefore sought redress at the court of law. But the court stated that it had been stated specifically that for you to trade in fertilizers, when you are selling the fertilizer, you must have an invoice where you are paid or whether you are not paid. The plaintiff failing to provide or to issue an invoice to the defendant by his or her performance made the contract that was legal to become illegal. Here, the plaintiff was the one responsible and therefore was the one who was to be held liable for the illegality of the contract. In this sense, the defendant can decide whether or not to pay or not to pay the plaintiff, since it was because of the plaintiff's act that made the contract illegal. The second thing you have to also consider is that the innocent party in such a situation or in such a contract can sue to enforce the contract against the party that made the contract illegal. I have stated previously that the party who made the contract illegal will be held liable. And therefore, the second thing you have to note is that the party who is innocent in a contract that has become illegal will be able to enforce the contract against that party by suing in the court of law. In the case of Archibald versus Panglet, the court held that in a contract that the performance has made the contract illegal, the innocent party can hold or can sue to enforce such a contract against the party responsible for making the contract illegal. The third factor or the third thing to note is that if it is established that both parties were wrong in performing the contract and has made the contract illegal, then they will both be held liable. For example, a contract that would have been legal being performed by both parties may render the contract illegal, and therefore the court cannot enforce that contract, and due to this, the parties will both be held liable to the contract. In the case of Ashmore versus Dawson, which was a contract for the carriage of goods, in this contract, both parties knew that the driver who was to deliver such goods did not have the required license to deliver such goods and still went ahead to make the driver deliver it. In this situation, the court held that both parties were very much aware that the contract that they were performing, though was legal, but the way they made the contract performed or the way they performed the contract rendered the contract illegal, and therefore both parties were liable for the illegality of the contract. So far, we have discussed what constitutes illegality and also the effect of illegality on a contract. The last thing to note under illegality of a contract is whether or not monies paid under illegal contract can be recovered by the parties. The general law is that, or the general rule is that, monies or properties transferred under an illegal contract is irrecoverable, meaning you cannot recover your money that you have paid or your property that you've disposed of in a contract that has been rendered by the court or by the law or by public policy to be illegal. You cannot recover such properties or such monies. But to every general rule, there are exceptions. There are exceptions to this general rule that where monies are paid under illegal contracts, such monies are irrecoverable, meaning monies paid under certain illegal contracts can be recovered by the parties or by the party who wants to recover such monies. In the case of Parkinson versus College of Ambulance, the court held that telling the other party to invest money in order to secure their position in a knighthood was rendered to be an illegal contract, and therefore the party could not recover their money. We are now going to look at the exceptions to this general rule that monies paid under illegal contract cannot be recovered. The first exception is that where the plaintiff can make his claim without relying on the illegal contract, the party can recover their money. In simple words, if you want to recover your money under illegal contract, you must prove to the court that you are not relying on the illegal contract to recover your money, but you are rather relying on something else or another thing to recover your money. In the case of Amasewa versus Gariba Hashimu, in this case, the defendant promised to marry the plaintiff and told the plaintiff to engage in sexual activities in order to get a lot of money so that he can use that money to marry the plaintiff. The plaintiff also engaged in these sexual activities and had a lot of money and told the defendant that now I have the required money for you to marry me. The defendant breached his promise to marry the plaintiff. The plaintiff sued. In her suit, she sued against the defendant for breach of promise to marry and not the monies that she paid out of the prostitution to the defendant. The court held that they can enforce such a contract as the plaintiff could claim her reliefs without relying on the illegal contract. The second factor is where the parties are not in pari delicto, meaning they are not of equal fault. In a contract where both performance or the contract from its inception is illegal, when the court is faced with a situation where a party wants to recover his or her money or a property that he or she has disposed under such an illegal contract, the courts will consider whether or not both parties were equally at fault or both parties were equally at fault in rendering the contract illegal if the court comes to the conclusion that both parties were not equally at fault and that there is an innocent party in the contract. The court can render such an illegal contract legal and allow the innocent party to enforce the contract against the party responsible for the illegality of the contract. In the case of Quartin versus Donko, the court held that since both parties were equally at fault, the plaintiff could not sue to recover their money. Meaning, if they were not equally at fault, the court would have rendered the illegal contract legal and allowed the innocent party to enforce their contract against the party responsible. Another exception is class protecting statute. Class protecting statute simply means that there are a group of people that when they enter into an illegal contract, the law will still protect them and allow them to enforce the contract. For example, are illiterate persons. When an illiterate person enters into a contract with someone who can read and write, and that party is very much aware that the contract is illegal, but does not bring it to the attention or that does not bring it to the notice of the illiterate person by explaining it in the language that the illiterate person understands, the court will allow the illiterate person to enforce the contract against the other party since it was the other party that made the contract illegal. The Illiterate Protection Act, Section 4 of the Illiterate Protection Act speaks more about this. So I would recommend you read Section 4 of the Illiterate Protection Act. Also, minors are also covered under class statute protection laws or class protecting statute. When a minor enters into an illegal contract, the contract cannot be enforced against the minor. We have already discussed a minor's capacity to contract in our previous videos, and therefore I would recommend you also refer to the previous videos on capacity of minors to contract and where a minor enters into an illegal contract. If it is not for the three exceptions, the contract will not be enforced against the minor. The last thing to consider is where one party in an executory contract, knowing that the contract is illegal and therefore decides not to engage in the contract any longer, the court will allow such an exception to operate. This means that although both parties were aware that the contract that they have entered into is illegal, or one party has contracted or has performed their part of the contract in an illegal manner, or where both parties are at fault or equally at fault, but then one party decides not to proceed with the contract, the party that has repented from performing an illegal contract will be protected by the law, and that exception will allow that party to recover any money that they have disposed of, any money that they gave or any property they have disposed in such contract, they can recover it. So far, today in our discussion, we have discussed illegality of contract and its obligation. We consider what illegality is, the two factors that render a contract illegal, and also the exceptions to such factors. And we also discussed the effects of illegality. We looked at why the contract is illegal from its inception and where the performance by one party renders the contract illegal. Thank you for joining our discussion on illegality of a contract. Once again, my name is Jacqueline Opoku and this is the Law Lab. Here we dissect and unpack everything legal. Thank you.